Real estate buyers, sellers, and realtors are frequently relieved to learn that transferring real estate after the owner of a property has died is often very straightforward. It's not always the case. There are certainly exceptions. There are times where the process can be quite frustrating or difficult, but by far and large, the process is pretty easy. And I want to be clear that the content that I'm sharing in this video is state specific. I am a Pennsylvania estate planning and real estate attorney. And so the information that I'm going to provide, which primarily relates to estate administration, is state specific to Pennsylvania. The fundamental questions are who has legal authority to transfer title and how is that legal authority acquired? Let's first look at who has legal authority. And we'll start with the easy example. So the number one question to ask when you're trying to figure out who has legal authority to transfer title is, what does the deed say? Ownership rights in real estate are governed by the deed. And the deed will spell out within the document who has legal title to the property and therefore legal authorization to transfer title. There are a few different ways to hold legal ownership in real estate, and we're going to talk about them starting with the most fundamental, which is fee simple ownership. Fee simple ownership is often described as the greatest possible property interest that one can acquire in land. Gives the owner all of the traditional property rights and the ability to dispose of the property at the will of the owner. So that could be during one's lifetime, or the ability to transfer the property based upon the directions of the fee simple owner at the time of their death. Another common way to hold ownership rights in real estate is through joint tenants with rights of survivorship. In the event of a joint owner's death, the property automatically passes to the surviving joint tenants. Because the deed transfers the ownership interest of a decedent to the remaining joint tenants, there is no need to probate. So jointly held real estate, as long as one of the joint tenants is still living, is considered a non-probate asset, which means that probate is not necessary to transfer title. If you're going through a traditional transfer with a title company, they will likely want to see a death certificate to prove that the joint tenant has deceased and therefore is incapable of executing the deed. At the death of the last to survive joint tenant, probate would be required to transfer title. We'll discuss this a little bit more in a moment. The next type of ownership is tenants by the entireties, and this form of ownership is exclusive to married couples. It is effectively the same as joint tenants with rights of survivorship, where at the death of one of the spouses, the surviving spouse will automatically take complete fee simple ownership of title to the property. Again, as long as one spouse is surviving, this type of real estate is considered a non-probate asset or jointly held asset, which passes automatically at death, and probate is not required. At the death of the last surviving spouse, so after both spouses have passed, probate would be required to transfer title to the real estate. If one spouse is still living, that spouse may freely transfer title to somebody else. And again, the title company will probably want to see a death certificate to prove that the spouse has predeceased and therefore the surviving spouse has complete legal authority to transfer the real estate. If the property is owned by a trust, the trustee is the person who has legal authority to transfer title. In Pennsylvania, trusts or revocable living trusts, the specific kind of trust, are not very common. They're not as common as they may be in other states. I've handled hundreds, several hundred real estate transactions, and I could probably count on one hand how many times one of the parties was a trust, either the buyer or the seller of the property. It happens very infrequently. If you fall within one of these previous examples, transferring title can be really simple. As I said, the title company may just want to see a death certificate. So that's all that you would really need to produce to prove that the remaining tenant has the legal authority to transfer title. So that's pretty easy. If you do not fall within one of those previous examples, the answer to who has legal authority to transfer title becomes a little bit more nuanced, but don't worry, it doesn't necessarily mean that there will be any significant delays. It's just a process that needs to take place before somebody else can gain the legal authority that would be necessary to transfer title. If there isn't a person who has legal authority to transfer title after somebody passes away, the court will have to appoint either an executor or an administrator in a process called probate. Probate is the judicial process through which a representative, often referred to as the executor or administrator or personal representative, is granted legal authorization to act on behalf of the estate of a decedent. This will be the person who will have legal authority to make any transactions with the real estate. That includes signing an agreement of sale, negotiating the terms of the sale, and ultimately signing any documents that would be necessary to transfer title, including the deed. So if you're looking for a person to negotiate with, or if you're looking for the right person to be talking to, this is the right person, either the executor, the administrator, or personal representative. Those terms can be used interchangeably. They do have specific meanings under the law, but they all effectively serve the same role. Their role is to manage the assets in the estate, to protect them for the benefit of the beneficiaries of the estate, and to have any dealings with them. And they have the legal authorization to do that. So if you're looking for the right person, that's who you're looking for. We talked earlier about what information you might be able to gain from looking at the deed. So if you're looking at the deed and you see any of these scenarios, you will know that probate will be required. First, if the decedent was the only person named on the deed, ownership interest becomes an asset of the estate and probate will be required. If all other owners have predeceased, ownership interest becomes an asset of the estate and probate will be required. In a situation where there are tenants in common, this is where multiple owners have separate and distinct ownership interest in a single property. In this situation, when one of the tenants passes away, their ownership interest becomes an asset of the estate and probate would be required, but only for the decedent's share of the property. Many people wonder whether probate will slow down the process of transferring title to real estate, and the good news is that in most cases the answer is no. So let's take a look at the probate process. The first thing to do is determine whether or not there is a will. Now, in most cases, whether or not there's a will shouldn't make too much of a difference in terms of timing. The process is relatively similar, but just to draw a distinction, there is a small possibility that if the person died without a will, there could be a dispute over who should be named as the fiduciary, the court-appointed administrator, which we talked about earlier, who will have the authority to manage the assets in the estate, including transferring real estate. So in most cases, in my experience, dying without a will does not necessarily mean that the process will be more complicated. It just means that the person didn't choose an executor during their lifetime, and so the court has to appoint that person on behalf of the estate. I'd like to take a look at the probate process in a little bit more detail so that we can illustrate how quickly this process can take place and how quickly we can get somebody who is either appointed or sworn in to serve as a fiduciary so that the real estate can be transferred. So whether or not there is a will, the process is relatively similar. First, the person who is seeking to be appointed as the executor in the case that there's a will, or as the administrator if there isn't a will file a petition for grant of letters testamentary. So you can see that this is a standard form and it is 2 pages. So there's not really a whole lot of information that you need to include on here. So first you fill in very basic information about the decedent. You can indicate what the estimated value of the estate will be, whether there's any real estate. And then you have two options. You can check box A in the event that there was a will and the will named an executor, or you can check box B in the event that there isn't a will and you're asking the court to appoint an administrator. And just to point out here, there is preferential treatment for a surviving spouse and children to be the first chosen to serve as the estate administrator in the event that the person died without a will. And in section B, it asks you to list the individuals that were survived by the decedent, including the spouse and other heirs. One minor cause for a delay, although it's not necessarily common, is when a person dies without a will. And for example, there are multiple children that are all qualified to serve. We will often have the individuals who are children but not interested in serving in the role of the administrator sign what's called a renunciation. And we submit those forms along with the petition so that the court knows that even though there were other people that were qualified to serve, they've decided that they don't want to pursue serving in the role of the administrator, and they are effectively giving their blessing to have the person who is interested and who is filing the petition, that person should be appointed and then serve and have legal authority to act on behalf of the estate. If there are multiple people who are interested in serving and they don't want to serve together, they are vying for their right to serve as the administrator, this can cause a delay. There can be a hearing that has to take place, and a judge will have to decide who is best fit to serve in that role. And right off the bat, if you have one of those scenarios, you know that it's contentious, and so the court is going to take their time to make sure that they get it right. Now, this is one of those situations that can cause a potentially significant delay in transferring real estate, but the good news is that it is very uncommon. So the way that this works, we complete the petition. As you can see, it's a pretty straightforward document, and we take it over to the courthouse along with the executor or the person who's seeking to be appointed as the administrator, and we file the petition along with a will if there is one, and if there isn't one, then we file the petition alone, also with a copy of the decedent's death certificate. And at that point, the person who is accepting those forms will ask the executor or the administrator to be sworn in. They ask them to raise their right hand and affirm to perform their duties as the personal representative faithfully, and that process takes about 5 minutes, in my experience. In most county courthouses in Pennsylvania, these processes are very much streamlined, and like I said, 5 minutes, maybe 10 minutes at most, but it is a very simple, straightforward process. And from there, once the petition is filed, usually within 48 hours, sometimes 24 hours, the court issues letters and short certificates which prove to the entire world that the person has the legal authority to act on behalf of the estate and can immediately take any action necessary to transfer real estate. So that includes signing an agreement of sale and signing a deed. And it's really that simple. Now, I do want to caution people who are watching this thinking, wow, probate is like the easiest thing in the world. Getting the person appointed and giving them the legal authority to act on behalf of the estate is very straightforward. But from there, the executor or the administrator has a very serious role that they need to fulfill, and that includes a lot of other steps that are necessary to make sure that they're serving properly and they're doing everything that they need to do to make sure that the estate is administered effectively. So I don't want to give you the impression that it's the easiest job in the world. It's not. There's still a lot to do after the fact. But in terms of gaining the legal authority to transfer real estate, it really can be that easy. There are a few practical tips, things to understand and be aware of. Number one, when the executor transfers title, the title company is going to want a copy of the death certificate and a short certificate, which again is proof that the person has the legal authority to sign the deed. Another thing to be aware of is Pennsylvania inheritance tax. So Pennsylvania imposes inheritance tax on the fair market value of any assets that pass by reason of death, but in this case, we're talking about real estate. So whatever the fair market value is of the real estate, the inheritance tax will need to be paid at some point, and it usually happens months after the real estate is transferred. But the title company is going to want to take one of two steps. One, they may ask an attorney who is representing the estate to sign an affidavit indicating that they are almost personally guaranteeing that the tax will be paid. Or the second option, and this happens a lot, the title company will want to keep money aside to guarantee that the tax is paid. And often they want to keep more than what is estimated just in case there's more tax due than what they would have estimated. So often they'll keep 1.5 times the estimated inheritance tax. They'll keep it in an escrow account and will not release that money until they have proof from the executor that the Pennsylvania Department of Revenue has accepted their inheritance tax return and has approved the tax amount that was paid along with the tax return. So this question has come up to me. What gives the title company the right to hold money? And the answer is that when the seller, on behalf of the estate, signed the agreement of sale, they are guaranteeing that they're giving clean title to the buyer. And until the inheritance tax is fully paid, the Department of Revenue in Pennsylvania has an automatic lien against any real estate that is owned by the estate. So in order to convey clear title, they need to make sure that the tax is paid. So this is just something to be aware of. This comes up very often if you're working on behalf of a seller or a buyer where there is a real estate transaction involving an estate. I hope that you enjoyed this video. I hope that this information was helpful to you. If you like this content, please let me know, and I will look forward to seeing you in the next episode.